Hello, everyone. We are here with Rand Pinsky, who is a Santa Clarita divorce and family law attorney. Hello, Rand.
Hello, Rob.
Rand, today in this particular video segment, we want to talk about the issue of child custody and child visitation, which I understand can be a very contentious issue between parents.
I would say that child custody and visitation is probably the number one item that we discuss with our clients throughout the entire divorce process.
Now, what if the parents can't agree on those, the custody and the visitation issue?
Well, the courts have set up a very complex process, very comprehensive, to take care of situations where the mother and the father cannot agree upon a custody arrangement or what's called a parenting plan.
Okay, can you walk us through that process?
Sure. The first thing that happens is this. It's determined that mom and dad cannot come up with an agreement as to how custody should be shared among the parties. The courts are concerned of what is in the best interest of the minor child. So the first thing that we do once an agreement cannot be made is that the parties are ordered to go to custody mediation. This is a process where mom and dad are ordered to go to a trained therapist, a court employee, who will work with mom and dad and try to come up with a parenting plan. In Los Angeles, you are required to go to this custody mediation, but you are not required to actually come up with an agreement.
Now, is this what you call a conciliation court order, or is that something different?
No, this is a conciliation court, because you don't use the word conciliation because sometimes clients think that conciliation means you're trying to get the parties back together as husband and wife. So I like to use the term custody mediation.
So to understand this, the court is ordering the parents to go and try to work this out, work out the issues with a mediator of some sort.
Yes, with a trained professional.
Okay, now what is the judge's role in all of this?
Well, as I explained, if the parties cannot reach an agreement or a parenting plan through the custody mediation, now you go to a judge. And the judge has many options available to him. The first thing a judge can do is he can appoint what's called minor's counsel. Minor's counsel is an attorney that will represent the interests of the children. The attorney will speak to mom and dad, will speak to the child, and then at some future court hearing make a recommendation to the court as to what they think is best for their client.
What is this parenting plan assessment? What is that?
A parenting plan assessment is another tool that the court uses to try to determine what's in the best interest of the minor child. So here, the parties go to a similar person like the custody mediator, but here they spend 1 or 2 full days talking with the mediator, bringing in some collateral sources, and this parenting plan assessment officer will make a determination what he thinks is best for the minor child. Then we'll go to court on an afternoon. The evaluator will make a recommendation to the judge, and the attorneys and the clients have an opportunity to question or support the findings of this individual. If that doesn't work, or if the court doesn't want to use a parenting plan assessment, then they have another option of appointing what's called an outside child evaluation study. Now, this can become very expensive. It's very complex. The outside expert will spend 3 to 4 months interviewing, testing the parties, talking to collateral sources, and then will come up with about a 60-page report as to what they think is in the best interest of the minor child. The cost of this can run anywhere from $6,000 on up. So if the parties cannot work out an agreement, they're looking at some very hefty costs.
So it sounds like it would be in the best interest of the parents to try to work something out short of that.
It would be in the best interest of the children and the parents to work something out.
Now, I understand there's 2 different types of custody. Can you shed some light on that?
There are 2 types of custody. You will have what's called legal custody, and we have physical custody. Legal custody, and that's usually joint, meaning both mom and dad have equal say-sos in upbringing of the children, religion, education, driver's license, passports, sometimes even tattoos.
Oh boy.
Yeah.
Let's not get into that. How about that? What about
And then you have physical custody.
yeah, physical
Custody, that's where is the child going to be spending the majority of their time.
Okay.
We talked a little bit about that earlier as I talked about the process of custody mediation, minors counsel, these types of things. So that's what physical custody is.
Now here's an issue that sometimes comes up. People ask, does my child have any say in the matter?
A child can have a say, but it's very, very limited. Over the last 5 or 6 years, there's been a law passed that will allow a 14-year-old child to have some input into the custody agreement as long as certain parameters are met. So yes, a 14-year-old or older can have a say-so, but it's not an automatic thing.
Well, I want to thank you, Rand, for spending some time with us today. Child custody and child visitation can be very thorny subjects, I would imagine.
Very much so, and very emotional.
Very emotional, and I would imagine that having a lawyer who's been down the river, so to speak, would be a good thing to have.
Absolutely. Thank you, Rob.
And you serve the entire Santa Clarita Valley, correct?
Yes, I do.
You live here, as a matter of fact.
I do live in Santa Clarita. I've had my practice here for probably 15 of the 40 years that I've been practicing law.
So if somebody wanted to get in touch with you, how do they go about doing that?
Easiest way is go to my website, randpinsky.com, or please call me 661-295-4644.
Once again, thank you very much, Rand, for this the time you spent with us today.
Thank you, Rob.